The judge in New York presiding over the New York Attorney General's civil fraud lawsuit against Donald Trump laughed Trump's lawyers out of court during a hearing on Friday and threatened them with sanctions. This hearing related to dueling summary judgment motions. And folks, I'm not exaggerating. The judge actually laughed him out of court and said, I thought what you filed, Trump's lawyers, was a joke, was a prank. The real question right now, though, is will trial start on October 2nd, or will Donald Trump's mischief in the New York Appellate Department cause a delay? It's still scheduled, folks, for October 2nd. And I think that the trial judge may even be ready to grant summary judgment for New York Attorney General Letitia James on some of her claims. As the judge said to Trump's lawyers, you can't just lie on business records. You realize that, right? Next up, Jack Smith gets key smoking gun evidence in the prosecution against Donald Trump in the Southern District of Florida case for Trump's willful retention of national defense information and obstruction of justice. As Donald Trump's former assistant, Molly Michael, dropped a bombshell. Ready for it? Donald Trump would use classified documents as a notepad. He used it as a notepad to send her notes. And then when the Department of Justice sought the documents back from Trump, Trump told her, according to sources, quote, you don't know anything about the boxes, Molly. Also, Donald Trump filed an unusual motion on Friday. I guess unusual for mostly everyone other than Donald Trump. Filed an unusual motion with Judge Eileen Cannon on Friday, seeking to revise the schedule of Classified Information Protection Act discovery. But really what he's after here is to delay. He realizes how damning the evidence is against him. Then we go to Georgia, where things are even more damning and heating up in both state and federal court in the RICO case filed by Fulton County District Attorney Fani Willis. So here are the questions we're going to answer. One, why did Donald Trump join in motions of co-defendants that are actually incriminating him? What? And how did Donald Trump's co-defendant just get so humiliated in federal court? Perhaps the most humiliating federal court hearing I think I've ever seen a litigant be involved in, or at least one who purports to be a lawyer. We'll discuss. Also, a new billion-dollar shareholder lawsuit, or shall I say lawsuits, against Fox have been unsealed, and they pose an existential threat to the Murdoch empire. And this, as the billion-dollar Smartmatic defamation lawsuit is chugging along. Accountability season is also chugging along. Accountability season is here. I'm Ben Meiselas. This is Legal AF. A lot to discuss, but never a dull moment, Michael Popok.
And we're chugging along.
Chugging.
That's all I can say.
The little train that could. I think I can. I think, that's what when I grew up, that was my favorite book, The Little Train That Could. And when I would, I took gymnastics when I was 4 years old, Popok, and I was on the balance beam, and I would get nervous. And you know what they told me to say? I think I can. I think I can. I think I can. I can.
Did you?
Yeah. I can.
And you did. Unfortunately for Donald Trump, the little engine that could are two giant locomotives loaded with evidence and witnesses and cooperating witnesses for the prosecution, barreling down on him in 2 or 3 separate prosecutions. I wouldn't want to be Donald Trump as he sees Fani Willis or Jack Smith with a little engineer's hat tooting away on that train that he is now tied to the tracks on awaiting their arrival. It was a lot of fun having you on Wednesday. We normally have Karen on Wednesday. She was, as we like to say, away on assignment. And I think people got a kick of you and I doing Wednesdays together, at least, once in a while. And that we were a little more interactive on that one than usual. Sometimes it just is like, you do your thing and I do my thing, and then we do our thing together. But I think the back and forth was fun. And then there'll be a segment or two in this episode. We'll be able to do that as well, where we have a conversation. We're in front of 2 million people.
We could be like two conductors talking about the next train stop. What if we just kept on using train analogies? Because Donald Trump is certainly combusting in court as we look across the various cases. So when I said in the intro that Donald Trump got laughed out of the court in the New York Attorney General's civil fraud case, I'm not joking. I mean, the Judge Engoron, in this hearing on the dueling summary judgment motions, actually said, when I first heard the arguments that you filed, talking to Donald Trump's lawyers, I thought you were joking. I thought this was all one big joke, Judge Arthur Engoron stated, who also added that he had repeatedly ruled on the very same issues that were brought up by Donald Trump's lawyers in their summary judgment motion. So Trump filed a summary judgment motion asking for the entire case to be dismissed, regurgitating these rejected arguments, saying that New York Attorney General does not have standing to enforce the New York Attorney General law. Also basically saying there's nobody who's injured here at all. The banks weren't injured, to which the judge had repeatedly reminded Trump's lawyers the injury is to the fair market. The injury is to the people of New York. So Trump regurgitated those arguments, whereas New York Attorney General Letitia James put forward, something called facts, something called evidence, something that showed, for example, well, Donald Trump, you claim that the apartment that you live in is 30,000 square feet. It's 10,000 square feet, for example. So if you just look at a calculation of the square footage and you have the multiple of what that value is per square foot, even if we accept your fraudulent valuation methodology by your experts, you're still lying because you're lying about the size of your properties. And she went through methodically each and every one of the properties and says, Donald Trump is just lying about these. And here's his deposition. And Donald Trump's deposition goes, I treat my properties like I treat the Mona Lisa. It's just something that's beautiful and I don't need appraisals. And in any event, the Saudis would buy my Mona Lisas for anything, is what Donald Trump said. And Judge Engoron was not buying it. At moments during this hearing, he was apparently slamming his fists, on the table before him. And he was saying, look, you can't lie on business records and say nobody was injured. You were warned before about sanctions. And when you were warned, what you're supposed to do is not do the same thing over and over again. And I kid you not, this was Donald Trump's lawyer's argument, Popok. And then I'm going to toss it to you. Donald Trump's lawyer, Christopher Kise, who by all accounts, was a smart lawyer. This guy had a decent reputation, but he has to make arguments like this, quote, this is why billionaires are billionaires. These are his trophies. That's the argument that Trump's lawyer made, Popok. That wasn't chugging along. Trump's lawyer's not chugging along.
No, that train, the bridge is out in front of that train, and Goron, the judge, is trying to tell him, wave him off because they're heading over a cliff. I don't think we have to worry about an October 2nd trial date, even though there's going to be another hearing in the First Department Appellate Division, the first appellate court above the court that Judge Engoron is on, about whether the October 2nd trial date should be pushed or not. Because I think we're going to get a summary judgment in favor of the New York Attorney General finding civil fraud against Donald Trump and his organizations and executives without the need for a trial. And I think that's why he's never been that concerned about either having more time to have this hearing that you and I are now going to describe on this segment, which was the hearing. It was really a two-part hearing. It was a hearing on summary judgments, both filed by the state New York Attorney General and by Donald Trump's lawyers. Donald Trump's lawyers are like, we don't even need a trial. We agree. They all agreed on one thing. They had their own analogy. It was Alice in Wonderland. They both talked about through the looking glass, except it made more sense for the New York Attorney General and the lawyer that was arguing there, Andrew Amer, than it did for Chris Kice's argument. And then the second part of that motion hearing with Judge Engoron was on sanctions against Trump for his continued and his lawyers' continued raising of, as you said, Ben, frivolous arguments that have already been rejected time and time again. And just because some of the earlier arguments were made by a long departed Alina Habba doesn't mean that Chris Kice gets to keep raising them in papers over and over again, hoping he'll get a different result. I mean, this is how courts work. You take your best shot, you make your argument in paper, orally, at a hearing, at a trial, on paper. The judge rules. You may disagree and you can ask for reconsideration or re-argument on that issue. And once that is decided finally, and it lands on the table and in the record books, you're done. You don't bring up defenses long since dismissed by the judge or arguments long since rejected just because you got some time on the clock at another hearing. And that's why, and costing the New York Attorney General time and money and delay. And so that was the second part of the hearing. But we had a piss and vinegar Judge Engoron. This is the first time we've seen him. First of all, it's the first time we've seen him in a hearing in a long time. And it's the first time since he's been sued by Donald Trump and his team, suing him under what's called an Article 78 proceeding, but naming him specifically in his official capacity as a judge to take a direct case to the appellate court, not on appeal, but for the appellate court to order Judge Engoron to do something, which for Trump is stop the trial in October. That whole Article 78, where Judge Engoron had to go out and get his own lawyers, I mean, the lawyers assigned to him from the court system anyway, is going to have a hearing next week. Because as we said a couple of weeks ago on LegalAF, Trump did convince one of the justices of the this first level appellate court to stay the October 2nd trial date, nothing else in the case, until a full 5-person panel of the First Department could make a ruling. That hearing is going to be next week. But they've already, Judge Engoron, now having been sued, having told the parties, you are going to have plenty of time to get ready for October 2nd. I'm going to hold a hearing on summary judgment for both of you soon. He did yesterday. I'm going to tell you which of the 12 pieces of property that the New York and transactions that the New York Attorney General is claiming there has been overinflation of asset value by Donald Trump in order to overborrow from banks with assets that don't support the loans at amounts that don't support the value of the true value of the property. I'm going to tell you which properties are in the case that you need to argue for trial, and which cases, because of a June ruling by the appellate division that Trump was partially successful in, are outside the statute of limitations. Because Letitia James, the New York Attorney General, does have a slight a time problem, because she brought her case. It took her so long to develop it, like 5 years, that some of the claims fell off the continuum as being valid claims, and because they're time barred, meaning every cause of action, state or federal, has a statute of limitations that goes along with it. No, I'm not talking criminal. I'm talking civil now. And a number of these, a couple of these transactions and properties, therefore, that were at the heart of her case fell off as being time barred. That's okay, because others didn't, like Lago, which was overestimated, according to the New York Attorney General, by every year by $250 million or more, or 40 Wall Street, which is a sort of a trophy property that Donald Trump considers about a half a block from the Federal Reserve downtown in New York. That has been overestimated, according to the New York Attorney General, by $500 million every year. Let's use this as an example. Suppose you only have $1 in your bank account, and you have the $500 million fake valuation for your property. well, then you really only have $1. Because if you go to the bank and says, I have $500,001 and I'd like to borrow money, please. And the bank says, well, let me take a look at that. Do you have an appraisal? Oh, yes, it's an appraisal from my mind. It's an appraisal on what I think it's worth because I'm a billionaire developer, and anything I say is should be followed, which is Chris Kice's argument in the courtroom, which led to a lot of laughter and banging on the bench by the judge, which was I wouldn't invest $1 based on what the New York Attorney General has to say because they are undereducated in the area of real estate. I would follow Donald Trump, and whatever he says is right, Judge. To which by the way, the judge said at one point, you understand that if you misstated the value of properties, even though you claimed there was no victim, there could still be a fraud, right? A fraud on the marketplace, on the fair operation of the market, because your guy's getting an advantage because he's lying to the banks about the value of his property. They have limited money to lend because banks don't have unlimited money. They have limited money both by regulation and their own balance sheet. And they overlent to your guy so they couldn't lend to the person right behind him in line. And the asset was not properly supporting, a value of asset was not properly supporting the loan at all. So should there have been a collapse, the bank would have been not securitized. You understand all that, right? And Kais was like, but I would put my money wherever Donald Trump told me to put my money. Okay, here's the result. On the at least 2 of the 12 major properties, which is almost $1 billion in her case, Mar-a-Lago and 40 Wall Street, I believe that a very robust decision from Judge Engoron on Tuesday, that's when it's coming out, is going to rule in her favor on a number of these properties, saying we don't have to worry about October 2nd for a trial because I'm finding as a matter of law on the undisputed record, I don't need to hear any other testimony, that she wins on her civil fraud case. As to Donald Trump's motion to dismiss the entire case because no banks have been defrauded and he paid back all of his loans, I'm sorry, that's not a defense to the civil fraud case at all, and I deny your motion for summary judgments. And on your sanctions, yeah, you kept raising frivolous arguments I've already dismissed, and I'm going to find that the Attorney General is entitled to money as attorney's fees and reimbursement as a result of that. That's why our first appearance for Engoron since he's been sued, he's so sort of piss and vinegar, yet calm in his own approach, because he doesn't care about the October 2nd trial date. The court next week is going to have to decide, Ben, whether October 2nd matters. The only reason that Trump asked for it to be delayed was to give the judge more time to rule on summary judgment. Well, Tuesday, after the Jewish holiday, he's ruling on summary judgment, and to allow them to have more guidance on being prepared. He has made it clear that he believes he's made the right decisions in the case, that he's following the appellate court and their directions on how to separate the time-barred claims from the non-time barred claims, that he's not trying this case in front of a jury. It's going to be tried in front of a Judge Engoron anyway. He's the same guy deciding on these issues, and everybody should remain ready on October 2nd for a trial. I'd be shocked, although it could happen, if next week the appellate court says, yeah, so October 2nd doesn't work. Let's just push that off another time, and then collide with all of the cascade of other civil and criminal trials that are already booked on Donald Trump's dance card.
Well, here's the thing. A train can only move forward if it's on the rails. And almost no matter what the appellate division does, this train's still going to be on the rails because it's a bench trial, right? And the summary judgment from what we've heard at oral argument is going, I think, and I agree with you, Popok, is going to be dispositive on a lot of the claims being brought by the New York Attorney General's office, to the tune of at least tens of millions of dollars and likely hundreds of millions of dollars in damages. So the liability trial phase, if you will, I think is going to be decided on Tuesday when we get this ruling. I would be surprised if Judge Engoron didn't grant summary judgment to any of the things New York Attorney General brought, but we will see about that. But talking about what's going on in the appellate division, there was a filing by New York Attorney General Letitia James' office and says, look, what the one appellate judge did was nothing to do with the merits, just got a document and said, okay, it's an important case, so let's bring it before a 5-judge panel. But the New York Attorney General's office points out, like, even if summary judgment occurred, you would not be entitled to an Article 78 proceeding, even on a summary judgment. So to try to usurp the power of a judge, a trial court judge, even before ruling on a summary judgment, and by the way, the summary judgment's about to be ruled on, that's not only unprecedented, it's just totally made up. It's not even a thing that exists, is what the New York Attorney General's office argued to that next tier appellate department. And so I'm not really worried that appellate department's going to do anything to truly move the train off the tracks here. And then I'll just make this one other kind of comment. Donald Trump's lawyers' arguments would be like if Bernie Madoff ran for president, basically used the office and the accoutrements of the office to then basically say, you know what? Yeah, I may have defrauded everybody, but I'm able to cover it now because the Saudis are going to pay me because of the proximity to power. And don't worry, now banks will lend me money because of my personality. So even if I've screwed around for a decade, it's cool now because the people really weren't injured who I defrauded and stole their money. I paid them back. And you would still say, but you still committed fraud.
You can make it even simpler. If I rob a bank in the morning, but in the night I have second thoughts and I put it back, it doesn't mean you didn't commit a crime, or in this case, civil fraud. And so that was when the judge was reportedly banging on his bench, which is never a great sign. I've been an advocate in front of the New York State Supreme Court. I just tried a case in front of another version of that court last week. I've been in front of the First Department Appellate Division, which is what's going to be ruling on this weirdo, as you said, out of regularity motion or petition to try to get the trial judge to do something in advance of him doing something. It's not a good day when you have a judge pounding on the podium. I once had a case where the judge got so frustrated with my opponent. We had already dismissed the jury on an argument about whether he had mistried the case by introducing evidence he shouldn't have. The judge picked up a giant binder clip and just threw it into his bench. Never a great place to be when the judge gets so frustrated with you. And I think what we saw here was a judge in full bloom with a lot of confidence, and his first time taking the bench since he's been sued, saying, I am not worried about my bosses at the First Department. I've made the proper rulings. I understand, Mr. Keiss, what the appellate court ruled in June about which of the transactions and people, because that's how Ivanka Trump got out. For those that, again, we try to make this both episodic so you can follow along, and also a series in terms of LegalAF. Ivanka Trump is not here because of the statute of limitations ruling over the summer by the same appellate court, although it'll be a different group of judges. And she just sort of, I haven't been around since 2017. And they were like, well, you're outside the statute of limitations. But, and Goron got his opportunity to talk as well. There's different stakeholders and different audiences during a hearing like this. The judge gets to be the judge. Keiss gets to trot out some old hackneyed arguments and defenses that make no sense at all. And we got to see the chief lawyers for Letitia James. She didn't actually handle the hearing. One of her assistant attorney generals did. And he did a masterful job with his slideshow of talking about the fraudulent value, which they've now estimated at a $3.7 billion hyperinflation, false inflation of financial statements for Donald Trump. And one of the pieces of evidence that they put up on the screen, Ben, I don't know if you caught it, was Donald Trump himself signing a certificate attesting that the financial statements were true and correct and consistent with generally accepted accounting principles, when we know now from his testimony that was a lie, that he picked numbers out of his backside based on how he woke up in the morning. I look over at my building. I think my building's worth $300 million more today. I think my apartment is 30 times bigger than it really is. And they also put up a quote from Weisselberg, the disgraced CFO who just spent 6 months at Rikers Island for tax evasion and fraud in another case, in a criminal case, where he said, they asked him point blank, well, The Trump apartment in Trump Tower, that's what it is 10,000 square feet, not 30,000 square feet, right, sir? He said, yeah, that was a mistake. And then, to which the lawyer for Letitia James says, we agree. It was a mistake. The only question that Engoron asked that was interesting was, not that I think that that these facts are present, but he said, what if the other side, Donald Trump and all, made an honest mistake? Would that still be potentially fraud under this unique statute and powers that the Attorney General's office? And Andrew Ware said yes. He said that it could still be an honest mistake, but if it defrauds the market, right, and it makes it unfair in the marketplace, which is what they're trying to regulate, that everybody plays on the same playing field, not a tilted playing field of Donald Trump's making, where he gets all the advantages because he's making up appraisals, he's what I call over borrowing money, he's taking money away from the next borrower in line because banks have limited dollars. It's a zero-sum game, literally. And so he said yes, under the 63-12 executive law that the New York Attorney General is under, it could still be. And if that was the only question that, frankly, Engoron had in his mind, we're going to see, and you and I and maybe Karen are going to be talking about the ruling on Tuesday, which will be in advance of the appellate division. They're going to say, we think this hearing is mooted. We don't need to do anything. You can't in advance say that the judge is about to make an error. You got to let the judge make an error. And then if he makes an error, you take a normal appeal and you argue the judge was wrong. But you can't say, we think, based on the fact that he doesn't like us and he makes comments and he bangs on his podium and his whatever, that you have to stop him from doing that. The trial judge has broad discretion to run the trial, make the rulings on a bench trial, certainly. And then if you don't like it and you think there's reversible error, take it up on appeal.
Big special counsel Jack Smith updates. We're learning that a key witness has told special counsel Jack Smith that Donald Trump was using classified documents as his notepad. We've got that and a lot more to discuss, folks. This episode is popping off. Don't get sidetracked. You got Ben, Popok, and all the bells and whistles. Choo choo. We'll be right back after this quick break.
I like knowing exactly where my meat comes from. And with Moink, that place is from small family farms all across the country. You can help save the family farm and get access to the highest quality meat on earth when you join the Moink movement today. Moink delivers grass-fed and grass-finished beef and lamb, pastured pork and chicken, and sustainable wild-caught Alaskan salmon straight to your door. Moink farmers farm like our grandparents did. And as a result, Moink meat tastes like it should, because the family farm does it better. The Moink difference is a difference you can taste, and you can feel good knowing you're helping family farms stay financially independent too. You choose the meat delivered in every box, like ribeyes, to chicken breasts, to pork chops, to salmon fillets, and much more. Plus, you can cancel anytime. Moink is helping save rural America. I love it, and you will too. Join the Moink movement today. Shark Tank host Kevin O'Leary called Moink's bacon the best bacon he's ever tasted. And Ring Doorbell founder Jamie Siminoff, he jumped at the chance to invest in Moink. Plus, they guarantee that you'll say, oink, oink, I'm just so happy I got moinked. I know I do, and you will too. Keep American farming going by signing up at moinkbox.com/LegalAF right now. And listeners of this show get free ground beef for a year. That's 1 year of the best ground beef you'll ever taste, but for only a limited time. Spelled MOINK box.com/LegalAF. That's moinkbox.com/LegalAF. With my active recording schedule and law practice, I can't function without a great night's sleep. And the bed's temperature in my old bed always seemed wrong. It was either too hot or too cold, but never just right, making for a terrible night's sleep. But I'm so excited to say that this episode is brought to you by 8 Sleep. There's nothing worse than tossing, turning, or sweating in the night because you're uncomfortably hot or cold. The pod cover by 8 Sleep will keep you cool all night, all the way down to 55 degrees if you want to, or make you feel warmer for the fall and winter months. So you wake up fully refreshed. The pod cover by 8 Sleep fits on any bed like a fitted sheet. The pod cover will improve your sleep by automatically adjusting the temperature on each side of the bed based on your and your partner's individual needs. It can cool down and warm up and adjust based on the phases of your sleep and the environment that you are in. I love 8 Sleep. Look, we spend almost half our lives in bed, so improving our sleep routine, habits, and overall sleep quality should be a priority for everyone. I love the temperature control and that both my wife and I can set our side to each of our likings. I also love the gentle vibrating alarm option for each morning. I wake up feeling refreshed after a great night's sleep, allowing me to start the day off right. 8 Sleep's technology is incredible. While temperature is the biggest game changer, the pod cover has other amazing features. For example, thanks to the pod's sleep and health tracking, you can wake up to a personalized sleep report for each morning that offers insights on how certain behaviors, like late night exercise or that cup of caffeinated tea or coffee, can impact your sleep and overall health. The pod cover by 8 Sleep truly provides the ultimate sleep experience. I've never experienced sleep like this, and the pod's cooling and heating technology has been a lifesaver. Invest in the rest you deserve with 8 Sleep Pod. Go to 8sleep.com/LegalAF and save $150 on the pod cover. That's the best offer you'll find, but you must visit 8sleep.com/LegalAF for the $150 off. Stay cool with 8 Sleep. Now shipping within the US, Canada, the UK, select countries in the EU, and Australia.
We are back live on Legal AF. Let me just say this. The Moink food is incredible and supporting American farmers while eating incredible food. I'm all for it. Let me just say this about 8 Sleep. It's like the greatest thing in my life. I'm just being for real. Like, I talk to people about 8 Sleep all the time. I didn't know what to expect when I installed the 8 Sleep on my bed. But when I go to bed and the 8 Sleep temperature thing goes on and it like engulfs me in this like nice, cool feeling, I've never experienced anything like it. I'm just being as real with you as I could be anyway. Let's get back.
No, I got one thing. I got one thing I thought of though at the break for it, because you brought up I love this train analogy and the fact that we're now conductors. I feel like you and Cohen doing the thing.
Well, still, yeah.
But for the audience that trends towards my age group, for me it's the neighborhood of make believe and the train set on Mr. Rogers, and Trump has become, for those, a shout out to King Friday the 13th. Because that is more like Trump every day. A guy who lives in a fantasy world made up of his own reality that has no place inside of a real courtroom.
Well, and he constantly sabotages himself. You may not know this. The word sabotage, Popok, comes from the practice of striking French railway workers, of cutting the sabot, the metal shoe that held together. So that's where you get the word.
Did you do that during the break?
I am an encyclopedia of train analogies. Let's get right. Let's get right. I didn't know where you were going to go with that. Let's get into it though. Total train wreck again for Donald Trump this week, with special counsel Jack Smith getting key evidence from Trump's former assistant. She worked with Trump in the White House. She worked with Trump at Mar-a-Lago. And according to sources, ABC first broke the news. And I think the sources may be her, or her lawyer or people very close to her. She has told special counsel Jack Smith that Donald Trump used the classified documents as a notepad. Interestingly, when the FBI executed the search warrant back in August of 2022, they didn't find those documents. But when she returned to Mar-a-Lago, she saw those documents underneath her desk. So not sure if the FBI was kind of testing them, leaving some documents, or if the FBI just missed it. But apparently she reached out to the FBI immediately and said, hey, I've got these classified documents that Trump would write notes on. So we learned that. And also, according to sources, Donald Trump told her, you don't know anything about the boxes. In the ABC article, they're like, we don't know what that means. Okay, we all know what that means. Let's be clear. Popok, how big is this?
Oh, this could be the equivalent of Cassidy Hutchinson blowing things wide open about Jan 6th, Oval Office, Mark Meadows, Secret Service, and Donald Trump. It's that big. Molly Michaels is, unlike others, is an unimpeachable witness. She is, and I think it's not just Molly Michaels about Mar-a-Lago and the texting and the pictures exchanged between her and Walt Nauta, which I'll talk about next, and the note-taking that Donald Trump had, and then someone hid under her desk organizer that she then found and gave quickly to the FBI after their summer execution of the search warrant. She is also the gatekeeper in the White House when she was the executive assistant. She was the head secretary or executive assistant that nobody was supposed to get by her to get to see the president. On Jan 6th, she was out for the day. What a day for her to run personal errands. And it was, as some of the reporting has said, shambolic and just a shit show in the White House, with Mark Meadows and others and people gaining access and Rudy Giuliani and all of that. And one of the reasons they've speculated is that Molly Michaels, who's identified in the Mar-a-Lago complaint as Trump employee number 2, and we now know is Molly Michaels, but she, and now that we know that she's cooperating with Jack Smith, she ain't just cooperating on Mar-a-Lago. She's cooperating on all the run-up to Jan 6th, all the November and December major events that she was a witness for, that she'll be a witness for the prosecution and a witness to history. And she is, I mean, there's, Donald Trump can go attack Cassidy Hutchinson. I barely knew her, don't know who she is. Molly Michael was his right-hand assistant, both at the White House, who followed him to Mar-a-Lago, and not coincidentally, is no longer in the employment of one Donald Trump. And so when we saw them listed in the indictment, when you and I were unpacking the indictment in Mar-a-Lago, and we saw what was Haley Harrison, who was Trump employee number 1, who currently still works for Melania. And then we saw Molly Michael. We were like, and you and I did a hot take on it at one point, one of us did, about, Molly Michael, remember that name, because she knows so much and has been a fly on so many walls involving the things that matter to Jack Smith, that if they get her to flip, look out. And the flipping is, I don't know about flipping. I mean, she was never going to be indicted. It was just whether she was going to cooperate or not. Now, before we even get to the note-taking that he did on the back of classified documents and then hid them under a note organizer, apparently the FBI turned over everything but didn't find this set of documents. Even before that, Molly Michael, told, and of course the government has these texts, said that she was texting and speaking regularly to Walt Nauta to both move boxes in and around the White House, the Mar-a-Lago, and get them up to the personal quarters of Donald Trump for his personal review. Remember, Jack Smith has to have evidence that puts Donald Trump with his hands in the boxes, the 90 or so boxes, and making decisions for himself about which boxes and documents go to the National Archive, which boxes and documents get reviewed by his own lawyer, Evan Corcoran, and which don't. And Molly Michaels does that for him, because the government never got Walt Nauta to cooperate. So not only is there's texting between the two of them, and there's one text in particular, I can't remember, Ben, if it's reproduced in the indictment or not, but it's certainly been mentioned in reporting. And there's a photograph that Walt Nauta took of a spilled out box of documents that needed a new lid. And you could see classified documents spilled out on the floor. And he sends it to Molly Michael about getting Donald new boxes and everything. That's terrible for him. Because remember, when the government had documents on the floor that they used and they took photographs of to show what the execution of the search warrant looked like, he said, well, that can't be mine because I keep my documents very neat and organized. And that's wrong. There's other photos of the boxes with things hanging out and people putting them back in and stacking them up at Mar-a-Lago. So you got Molly Michael, Mar-a-Lago, key witness that Donald Trump will not be able, in the Mar-a-Lago case, he's never testifying. So you're going to get, the jury is going to see Molly Michael, not going to hear from Walt Nauta, no way does he testify, not going to hear from Donald Trump, but just a bunch of other maintenance workers and Molly Michael and others, and then these emails and texts and Yuscil Tavares, the IT worker, who's going to get on the stand in front of a jury. And look, if Donald Trump thinks, "Oh, I'm gonna get a hung jury," I don't know if you caught this, Ben. I'll turn it back to you. There is a recent conviction in Atlanta yesterday of a real estate developer for fraud. And they ran into a problem with one or two jurors, where one or two jurors refused to properly deliberate. You could substitute Trumpers in there. One of them said it's because she was defending white people's rights, and she claimed that another person was only going to convict white people. The judge held a hearing, interviewed the jurors, dismissed the jurors, and the remaining jurors convicted that real estate developer. So if Donald Trump thinks, well, if I'll only need one, if there's not an appropriate deliberation over evidence that's presented at the Mar-a-Lago trial, whenever that is, let's hope it's in May. There's ways around that. That's why you have alternate jurors. Molly Michaels should now keep, if he's not already up at night, Donald Trump up at night, because he has no way to go after her other than through cross-examination. And she is about as big of a saint in his world as possible.
Donald Trump is hoping that Judge Eileen Cannon's gonna help him out. That's what Donald Trump is hoping for. And I know everybody loves when I break down CIPA, the Classified Information Procedures Act, but let me get into it, because this is how I believe Donald Trump thinks that Judge Cannon could help him. So CIPA, Classified Information Procedures Act, deals with how do you handle documents, how do you handle classified documents in cases where there's discovery obligations and you're supposed to produce documents and records, and cases are supposed to be open to the public. So CIPA basically says, in addition to just regular confidential business records, which are often afforded confidential status and are handled a certain way, classified documents, which are often the fruits of a crime in a case involving them, have to be handled very sensitively. And there's pretty much a standard procedure, hence the Classified Information Procedures Act, a protective order pursuant to Section 3 of CIPA, Classified Information Procedures Act, which governs all of that. The appointment of somebody called a CISO, a Classified Information Security Officer, literally someone who works as almost like an independent monitor or a aide to the judge, who has a security clearance, who works and holds these documents throughout the case and literally shuttles documents if they have to be filed in court to make sure that they're protected. The documents have to be viewed in SCIFs, sensitive compartmented information facilities. You all remember when Donald Trump wanted a SCIF to be built at Mar-a-Lago. Well, for now, at least, Judge Cannon rejected that concept. But Jack Smith asked for the CIPA procedures, the protective order that should be entered forthwith, to happen back in June. Jack Smith's like, I'm ready to go. And the first thing that had to happen was Donald Trump's lawyers had to get a limited security clearance for purposes of being able to even be on the case. It took them a few weeks to even fill out the forms, pretty basic forms for them to file. And then Judge Cannon would strike documents that Jack Smith would file under seal. Judge Cannon also mistakenly scheduled the CIPA hearing to take place on August 25th in public. You can't hold Classified Information Procedures Act hearings in public. She then realized the mistake, had to continue it to happen under seal, which is the processes and procedures under CIPA. Then that hearing happened on September 12th. And then last week, or in the past 10 days or so, on September 13th, she finally entered the CIPA protective order. So mind you, from June to September 13th, she did nothing. This was the easiest thing to enter. Compare that to what Judge Chutkan, the federal judge presiding over the Washington, D.C. case for Donald Trump's attempt to overthrow the free and fair election of 2020 does, how she runs that courtroom efficiently and things get filed right away and things get ruled on right away. Judge Cannon waited months and months and months. So then here comes Donald Trump files this motion on Friday, refers to it as President Donald J. Trump's motion for a revised schedule for motions to compel and CIPA Section 4 litigation. Also, you're not the president anymore. If you want to say former president, that's fine, but you are not the president anymore. That's not a title that should be used on these cases. You are a criminal defendant. It should say Defendant Donald J. Trump's motion for a revised scheduling order. But in this motion, Donald Trump blames Jack Smith and says Jack Smith said that he was ready to go and that he would have these documents back in June. But now we don't even have a lot of these documents. And what is ignored, number one, is that the reason this all happened was because Judge Cannon didn't rule on the CIPA protective order, so those classified documents could not be turned over. Also, what Donald Trump's saying in this motion is also false. Jack Smith has turned over all of the classified documents. They have to be reviewed in a SCIF. Donald Trump doesn't just get to have them, but there are certain documents, probably the ones, if I had to guess, I don't know because it's not in this motion, that relate to the nuclear secrets and the war plans that Jack Smith does not want to turn over to Donald Trump's lawyers because Donald Trump will use them for bad conduct is probably the fear. But there is a process and procedure in Classified Information Procedure Act cases where the prosecutor's office, when a situation like this emerges, it's not improper to withhold the document. You could petition the judge on what's called an ex parte basis. So you go just to the judge on your own without even the other side there. And you say, Judge, here's the document. Here's our concern in even making this available to the defendant in a SCIF. We want to provide a summary under your guidance, Judge, in lieu of actually producing the document. And that's called a Section 4 CIPA proceeding. I know you love getting into the weeds of CIPA. So if you go to 18A U.S. Code Section 4 of CIPA, discovery of classified information by defendants, it sets forth this ex parte procedure. It says the court, upon a sufficient showing, may authorize the United States to delete specified items of classified information from documents to be made available to the defendant to discovery under the normal federal rules of criminal procedure, to substitute in its place a summary of the information for such classified documents, or to substitute statements admitting relevant facts that the classified information would tend to prove. The court may, in the form of a written statement to be inspected by the court in an ex parte hearing, order this relief to take place. So it contemplates an ex parte hearing at all. And because I guess Donald Trump's lawyers don't read the statute or expect Judge Cannon to make more mistakes, they act like this ex parte procedure under Section 4 is somehow novel and unique, and they whine about Jack Smith. He's withholding documents. He's not turning it over. First and foremost, Jack Smith couldn't do anything until September 13th. He was waiting on Judge Cannon. And then in the intervening 11 or 12 days or so, Jack Smith did make available certain documents, and the other, Jack Smith's availing the normal procedure under 18A U.S. Code Section 4 of CIPA. But at the heart of what Donald Trump is trying to do here is delay, because as you look through the motion, Donald Trump wants all of this briefing now relating to CIPA to take place through January 19th, 2024, instead of October 10th, I believe, is when the other date would be. So Donald Trump doesn't ask for a delay of trial here, but by asking for a delay of briefing on the issues of discovery and CIPA-related discovery to January of 2024, Trump is hoping to push back the trial date. This is the first step in trying to sneak that in. That's your in the weeds CIPA review right there.
That exhaustive description of CIPA proves another point for me. And Donald Trump has taken the bait. Mar-a-Lago is not the case he should be worrying about. And he continues to do battle with Jack Smith as Jack Smith takes Mar-a-Lago witnesses like Molly Michaels and converts them into witnesses to help him in the main case in front of Judge Chutkan. So it's almost like watching a boxer. You know, Muhammad Ali was famous for this. He would let the boxer against him tire himself out on the ropes for 7 or 8 rounds. This is one of the reasons that, unfortunately, Muhammad Ali also developed Alzheimer's, because he got punch drunk from doing this. But he was successful. He would just lay on the ropes and let the other guy punch himself out. And I see that as going on in Mar-a-Lago. Donald Trump shouldn't worry about extending briefing schedule for documents that are going to be produced, documents that he had illegal possession of. That's what we're talking about. It's not like he hasn't seen these. He's seen all these documents. If Molly Michael's testimony is right, he's looked through the 90 boxes in order to figure out which of the 12 he was going to deliver back to the National Archive, which of the subset of that he was going to let Evan Corcoran look at, and which of the 38 he was going to allow Evan Corcoran to stick in an envelope, give it to the government, like, see, we're done. So all of that is going on, and this whole charade of let's get into the weeds about CIPA and do federal briefings while Judge Chutkin chugs along and has already established her CIPA procedure for the bigger case is, again, I just see them using this case, the government, as the stalking horse, tiring out an under-resourced and undermanned and overmatched legal team for Donald Trump. I can't make this point any clearer than I have on this particular podcast or other ones. The entire legal team for Donald Trump, in Florida consists of 4 people plus a paralegal. That's it. Each firm, John Lauro's firm is like 2 people, and the firm for, it's not even Keiss, it's Todd Blanche, is another couple of people. That's it, against the United States of America Department of Justice. All right. So they're outmatched. And every moment that Jack Smith gets them tied up, or they tie themselves up, which is what they're doing in CIPA, and wasting time briefing and doing and appearing and arguing, is one less moment, one less lawyer hour that they can devote on the other cases, including Fani Willis's. So again, this is like sending the rabbit out and letting the dog chase it until it's exhausted. And I see, that's exactly what I see here. I see Jack Smith using Mar-a-Lago to pick up key witnesses for his other case, like Molly Michaels, while exhausting Donald Trump and an overmatched, out-resourced trial team on that side.
In many ways, the fact that Judge Cannon is so incompetent actually helps Jack Smith with that kind of smokescreen that's being created there, right? Knowing that Donald Trump has tunnel vision and he is so focused on these proceedings and he thinks he has a friendly judge in Judge Cannon, which he probably does. But there's kind of, as you kind of put pressure on that flank, and that's where Trump is so focused on, Jack Smith's team's getting ready for the big one. The biggest one of them all is the March 2024 trial for Trump's attempt to overthrow the free and fair election. I think that's a great point. Popok, we've got a lot more show. Want to talk about everything that happened in Georgia in the RICO case by Fulton County District Attorney. I'll tell you, I knew Jack Smith was great because Karen Friedman Agnifilo worked with Jack Smith. I had heard Fulton County District Attorney Fani Willis was great by reputation, but didn't know people who knew her other than just by reading things about her. She and her team are some of the most impressive lawyers on par with, and perhaps even some of their briefings better than I see at the top Department of Justice. I mean, some great lawyering. And I'm talking about not just the briefing, not just the writing, but the cross-examinations that I'm seeing and like demolishing these co-defendants who take the stands. It is a sight to behold. Also want to remind everybody, if you want to support the MeidasTouch Network, don't forget to check out patreon.com/MeidasTouch, patreon.com/MeidasTouch, MeidasTouch. We don't have outside investors here on the MeidasTouch Network, so one of the ways to keep growing this network is with your help. We appreciate it so much. We've got a lot more show. Let's take a quick break.
Our next partner is AG1, the daily foundational nutrition supplement that supports whole body health. I drink it literally every day. I gave AG1 a try because I was tired of taking so many supplements. And I wanted a single solution that supports my entire body and covers my nutritional basis every day. I wanted better gut health, a boost in energy, immune system support, and wanted a supplement that actually tastes great. I drink AG in the morning to start my day. It makes me feel unstoppable and ready to take on anything. And on top of it all, I'm doing something good for my body. I'm giving my body the nutrition it craves, and I'm covering my nutritional basis. I've tried a ton of different supplements out there, but this is different, and the ingredients are super high quality. I got started with AG1 because I used to take all these different pills and gummies, who knows what, and frankly, what I was taking was expensive, and I didn't even know if it was good for me. But with AG1, I know what I'm consuming has the best ingredients and also tastes delicious. AG1 makes it easier for you to take the highest quality supplements, period. When I started my AG1 journey, very quickly I noticed that it helps me with improved digestion, energy, and overall, I just feel great. It's just one scoop of powder mixed with water, once a day, making it a seamless and easy daily habit to maintain. I'm asked all the time about the one thing I'd do to take care of my health if I could only pick one. It'd be foundational nutrition, and AG1 is a top foundational nutrition product. Just one daily serving gives me the comprehensive foundational nutrition I need and supports energy, focus, strength, and clarity with 75 high-quality vitamins, probiotics, and whole food sourced ingredients. I can't think of another daily routine that pays off as well as AG1, which is why I trust the product so much. If you're looking for a simpler, effective investment for your health, try AG1 and get 5 free AG1 travel packs and a free 1-year supply of vitamin D with your first purchase. Go to drinkag1.com/legalaf. That's drinkag1.com/legalaf. Check it out.
Welcome back. We're live on Legal AF. Let's go to Georgia. Trump co-defendant Jeff Clark just getting demolished during a hearing that took place in federal court as he's trying to remove it. And then we go to what's going on in state court where Donald Trump is joining motions that would seem to incriminate him. Popok, what's going on?
Yeah, and I just did a hot take that's up and running right now on the MeidasTouch YouTube channel about what it means for, and you and I'll do this later, what it means for 2 of a 19-party conspiracy going to trial early. What it means for Chesborough and Powell going to trial October the 23rd this year, like a month from now, what that means for Fani Willis, Donald Trump, and the others, considering Donald Trump's trial is not going to be until 2024. Well, how do you put on a 19-person co-conspiracy case against only 2 people? And what does it mean based on winning or losing to the others? That's on a hot take. But here we got Jeff Clark, who you and I thought if anybody was going to have a shot at taking their case from their criminal prosecution into a different courthouse to have it tried, in this case, a federal courthouse also in downtown Atlanta, that it would be Jeff Clark. Mark Meadows, we already saw, had already failed with Judge Jones, who's the federal judge, who's the gatekeeper to keep all of these crazies away from the federal courthouse and put them back with Judge McAfee. And Mark Meadows even testified, and he lost, and is now up on appeal, which will probably be not likely to prevail, about whether he, as chief of staff, was within the scope of his job responsibilities and duties when he interfered with the election in Georgia and other places. And Judge Jones said no, and the 11th Circuit, I'm sure, I'm reasonably confident is going to agree with them, especially now that we know who the 3-judge panel is on the 11th Circuit, which is all Biden and Obama people. Okay. Same Judge Jones. Next up, Jeff Clark. We said, well, at least he's Department of Justice. At least he's in the executive branch. At least these lawyers do certain things like write letters and analyze things for their client. And so maybe, but then, in order to prevail at a hearing like that, which turns the tables on burden of proof. In a criminal setting, Jeff Clark doesn't have to do a darn thing. Prosecution has the burden of proof beyond a reasonable doubt that they committed a crime. And with Fifth Amendment privilege, that's why most people don't take the stand, because it's the prosecutor's burden. But when you're trying to take a case to federal court, it's your burden. And when it's your burden, you have to make out the burden of proof, which in this case is clear and convincing evidence that what you did was within the course and scope of your job responsibilities. And in order to do that, you generally have to put on evidence. And that's where Jeff Clark fell apart. because Jeff Clark didn't put on evidence. Jeff Clark sent in 2 affidavits, which are sworn testimony on a piece of paper under oath, but it doesn't allow the other side to cross-examine it and is generally not accepted at an evidentiary hearing. And he sent in one from what I assume was some sort of expert on what his job responsibilities were within the Department of Justice. And they went and yanked 91-year-old Ed Meese, the disgraced former Attorney General for Ronald Reagan, of all things, who had more ethical problems than probably any Attorney General not in prison, to submit an affidavit saying, well, I'm Ed Meese, and I took a look at all the facts here, and I think he was within the course and scope of his duties. And the judge says, with all due respect, I'm not accepting affidavits. If you want to testify live, you can. So there's no evidence. Now you're left with a double-talking, stammering lawyer for Jeff Clark, who also doesn't even understand his own case because he can't answer simple questions by Judge Jones about the timing of certain pieces of evidence and events. And so that went terribly, as instead Fani Willis's team showed up loaded for bear, as she always is, even in federal court, bringing witnesses, bringing receipts. She brings in as a lead witness Jody Hunt, who not only has a day job as Cassidy Hutchinson's lawyer, but he served in the Trump administration in the Department of Justice, and he had the job just before Jeff Clark had the job as the head of the civil division of the Department of Justice. And he testified quite credibly to Judge Jones that that's not the job that Jeff Clark had would not have been involved with election interference or election issues. That's the criminal division or the civil rights division of the Department of Justice, but not the job that he had. And so that came from the guy that held the job under Trump right before that. Powerful testimony. We're waiting on the decision by Judge Jones, but I would be shocked if he's found that Jeff Clark had met the standard to take his case to federal court. Everybody, here's an announcement. Here's a public service announcement. All 19 of the co-conspirators, you are going to be with Judge McAfee. Get used to that idea. You're going to be tried in 2 or 3 groups, 2 or 3 batches of co-conspirators in 2024. Hopefully Donald Trump in the first batch in 2024. And you get to watch, like the rest of us, what's going to happen to your 2 other co-conspirators in just a month as a dress rehearsal. And if they go down in flames, which based on the evidence that she has, I would, in front of a Fulton County, Atlanta, Georgia jury, I would not be shocked. Then listen for all the co-conspirators who have not yet been indicted, or even ones that have been indicted, to run for the exits and try to get to Fani Willis and cut a deal and then testify against Donald Trump and others as quickly as possible. That's my take on that. One last thing, Ben. Ken Chesborough is the gift that keeps on giving. He keeps filing things in court and putting in your and mine, Karen's hands, pieces of evidence from the case for Fani Willis we didn't even know existed. Last week, he filed a motion and he attached a transcript because the fake electors had a court reporter present because they were so proud of what they were doing in signing their name to the conspiracy and signing these fake elector certificates, that they not only had a lawyer for Donald Trump's campaign in the room, indicted Ray Smith, but they also had a court reporter taking a transcript down. So he attached the transcript like, see, this clears me. And I was like, wow, they had a transcript. You know, at a bank robbery, the robbers don't usually have a court reporter there writing down everything that just happened. That's amazing. You usually have a video of that. And then we said, great, we love Ken Chesborough. And then he does it again. We knew there was a search warrant for his emails to MSN, Microsoft. We didn't know what the contents of the affidavit and the testimony that the judge took in order to issue the search warrant to get his email. And so we get, and I did a hot take on it yesterday, we get like a 30-page affidavit from the investigator for Fani Willis, which lays out the entire case. Again, Ken Chesborough, Rudy Giuliani, Sidney Powell, David Schaefer, the former head of the GOP, all the other indicted conspirators, all in a neat package in an affidavit that you and I get to comment on. I love Ken Chesborough. He's not only going to get convicted, but he keeps telling us what the evidence is against him.
And Donald Trump, though, he has got a good lawyer out there, and Steve Sadow. By all accounts, Sadow's, again, competent lawyer, has represented a lot of people in big cases. And has done a good job. But why then is Sadow on behalf of Trump joining a lot of these motions of co-defendants. Like, Trump's not filing his own motions. One of the reasons I think, I'll get your take on it, is Trump still has this idea that he may want to remove the case to federal court. And perhaps if he brought affirmative relief, they would feel that that constitutes a waiver more than joining. Even though I think the same issues that we're seeing when these other people are trying to remove would present itself if Trump ever tried to remove this case to federal court. Maybe that's why Trump's joining, but he's joining motions that are basically trying to create distance between the various co-defendants and him by saying, hey, we were doing this because we were basically told to do it by him, and we were just performing our functions, whether that was as lawyers or fake electors or whatever it is. But then he joins that. And that's just very odd to me, because it would seem to be incriminating to him. What do you think?
Yeah, I don't know why he's doing what he's doing. I know you and I have this working theory about he's still holding out hopes and watching Meadows and Clark to see whether he can drag himself to federal court. But watching Steve Jones in action, the judge, I don't know why he'd want to be in front of federal Judge Jones other than the delay part. And he's already gotten the delay part because Judge McAfee has said, I can't logistically try 19 people at one table, and I'm not going to do it. So, Fani Willis, you come back to me with a more sensible and reasonable proposal for trying these in batches in 2024, and I'm sure I'll agree to it. So he's already gotten the delay part. He sees Jones is not going to be, yes, it's a federal jury that he would be on track for. So there's that theory that he thinks he's waiving, but I think if he's already waived, I don't get, he's dipped his toe in the water anyway. There is a clock that's running on removal. I thought he had already blown through it. Sadow so far is he's either crazy as a fox in just saying me too to these motions filed by Chesborough and Powell to see if he can get some mileage. I mean, one he was successful on. Chesborough, the one to sever and sever away from speedy trial. He adopted Rudy Giuliani's, and that got granted. But I don't really understand how it helps you. In fact, I think it hurts you to continue to pin yourself to co-conspirators, lawyers who led you down the wrong path, and including ones like Chesborough, who said, I never told Donald Trump and the others to use the contingent electors if there wasn't a valid legal challenge present. And we know there wasn't a valid legal challenge present at that time. And therefore, these, even under his own, Chesborough's own crazy crackpot theories, that fake electors should never have been sent to the National Archives or to Mike Pence and used in a pressure campaign. Of course, he says that, but when you look at the evidence that's in like the search warrant that was just affidavit that was just filed by Chesborough, you see there's even more evidence against him. So I'm not impressed yet by Sadow. Maybe he'll pull a rabbit out of the hat with some amazing blockbuster omnibus motion of some sort to dismiss the indictment at I don't know when. But we've already got in stark contrast to the Judge Cannon that we spent a lot of time on today about how she's kind of exhausting and screwing things up. We've got McAfee that is in firm control of his docket, his court procedures, his rules. There's only two people that know it as well as him, in that room. It's Fani Willis and Scott McAfee. And he said, for instance, on the upcoming trial, he granted Chesborough and Powell the ability to ask the former grand juries if they voluntarily want to talk to the defense team and the prosecution team about their deliberations. Given the fact the special purpose grand jury was doxxed and is basically looking over their shoulder to see if anybody's going to do some harm to them, I'd be shocked if any of the grand jury wants to, sit down and talk to the defense team. But the judge says if you reach out to them without harassing them and they volunteer to do it, we'll do it in my courtroom. I'll see the questions in advance under my supervision. But he would not allow them to get access to any part of the special purpose grand jury's notes, notepads, documents around that other than witness transcripts from testimony, because he said, I got to protect the security and the sanctity of the special purpose grand jury. As you said on Wednesday, every decision that this guy has made so far has been spot on, and it's almost one with which we can't debate. That's how well procedurally logistically, he is running his courtroom. And that's why he's got a trial that starts in a month on the major Fawny Willis RICO case. And then, of course, he'll handle the other cases. But like I said, Donald Trump and others, they can try to get out from under this and get to federal court. I just don't see the advantage to it at this moment.
You know, and accountability is coming on all fronts as well. And I want to talk briefly about Fox. And if they thought that their $787.5 million settlement Dominion was the end of it, well, they got about the same caliber legal advice that brought them down the path in the Dominion case in the first place. There was reports today that Murdoch believed, based on conversations with his general counsel, former general counsel, now Viet Din, who, by the way, was a law professor of mine for a short period of time at Georgetown Law before I recognized, why in the world am I taking a class with Viet Din and Paul Clement, the former Solicitor General in the George W. Bush administration? But it's funny how that all ties itself together. That was back in, 2008 or so. But Viet Din's no longer there at Fox. But there's a lot of other lawsuits, existential threats. Of course, we know about Smartmatic, that defamation case where Smartmatic seeking $2+ billion there. And this past week, the pension fund derivative shareholder lawsuits were unsealed. We had known that these were filed the week before, weren't able to read their contents. Now we were able to see how powerful these allegations are, filed by the New York and Oregon pension funds that represent police officers and firefighters and teachers and other groups that rely on them to make smart investments. And when they're investing in entities like Fox that double, triple, quadruple, or rather make their entire business model spreading mal and disinformation and defamation, and then settling these cases as part of that business model for hundreds of millions of dollars and soon potentially billions of dollars. Well, that hurts the investors. You have to remember how this is all tied together, and it has real world impact on people who invest in companies and expect board of directors to act as fiduciaries. So Rupert Murdoch left his role as chairman, says he's going to have this emeritus role this week, claiming it has nothing to do with the unsealing of these pension fund derivative lawsuits. Just so you know, a derivative lawsuit's when a shareholder of the company sues its own company for the damage and losses suffered by the shareholder by the breaches of these fiduciary obligations by the board. So all people who are named in this lawsuit, in addition to the company, are Rupert Murdoch and Lachlan Murdoch. Lachlan's now taken over the company as well. So it seems like Rupert Murdoch's basically saying, by leaving, hey, I built this. Good luck, Lachlan. You take it over. But there's multiple of these pension fund lawsuits. There's the New York pension fund and Oregon fund. There's some other funds and other pension funds and other standalone cases that are all going to be consolidated in the Delaware Chancery Court. That's where it's been filed. There's already been a lot of discovery under the Delaware rules that allow for discovery pre-filing in these derivative shareholder lawsuits. And now there's going to be a leadership fight over which lawyers and which groups and which funds are going to be leading the litigation, because there's a big group of various plaintiffs who are bringing this, represented by the top law firms in the country. So, again, I think this is existential to Fox's existence. And one of the things we know, too, is how much Fox wants to avoid going to a trial. They know that if Rupert or Lachlan or any of their executives are called to the witness stand, in addition to the monetary payout, they were all just so complicit in this. And not just complicit, but also would refer to their own viewers as idiots, and they hate their viewers. That's one of the most interesting things to come out of the Dominion discovery, is how much the various hosts know they're engaged in the scam. Like, they're not true believers in what they're saying. They know they're lying. They hate their viewers, but they are also afraid of losing the viewers because they're placing their lucrative careers over our democracy. Popok.
Yeah, it's interesting. I've been in this courtroom. I've been before this judge. I've defended cases in class action just like this one. Judge Travis Laster is a bad pick for Fox News, the Chancery Court judge assigned to this. He doesn't suffer fools. He has a very specific way that he wants these cases tried. He has a very good relationship and trust the plaintiffs' law firms that have brought these cases. There's actually three types of cases all in one that are being proposed. You've got the case of the New York controller and pension funds joined with Oregon in one what's called a derivative action, which means they're seeking to have the money that is obtained from the directors, from the officers, from the company itself, from the directors and officers, repaid back to the treasury of the company, to the coffers of the company, because all these settlements, the $800 million or so for Dominion, the $2.6 billion case that's sitting in New York State Supreme Court waiting to be tried by Smartmatic, and all the others, and the legal fees related to that. So let's just round it off to an even $3 billion. That's money that should not have been spent by the company if it wasn't for the poor stewardship, breach of fiduciary duty, and bad management by the board of directors and the operational executives like Rupert Murdoch, his son, the head of the news division, and the rest. And the board is sued as well. When you sue a company for derivative action, or even for what's called a direct action, it triggers all the insurance. There's huge stacks of insurance and reinsurance that cover directors and officers. So we're probably talking about $2 or $3 billion worth of insurance, plus money that these people are going to have to come out of pocket, because they're all wealthy, to put on the table as well. And there's actually the New York, Oregon case. Then there's another case of another set of pension funds. And there's going to be a fight in front of Judge Laster to see which of the plaintiffs' law firms, because it's very lucrative, they could get fees up to a couple of $100 million for their lawyers and their law firm just for representing these cases, which almost always settle. And so there's a fight that's going to be banged out by the 23rd of September in front of Judge Laster, where he picks the lead or co-lead plaintiffs' lawyers from, as you said, Ben, some of the finest law firms in the country that practice in that area. And they're also bringing class action or direct suits to get class action people, the people who invested in the company that are harmed by the misuse of the money, because their fundamental argument in both the cases, whether it's the 120-page lawsuit filed by the New York and Oregon pension funds, or the 170-page with footnotes complaint that's been filed by the other pension funds, you put it all together based on the evidence that was obtained already in the Dominion case and obtained through the books and records process down in Delaware. The case that's being made is that there is a fraudulent business model at Fox News, that Fox Corp has lost control of the content at Fox News completely. They've abdicated their responsibility to manage it, and it is just a house of cards based on a defaming machine that does not look into whether anything they're saying on television is true or false, leading them to be exposed to liability for defamation against, whether it's the Ruby Freeman and Shay Moss election workers of the world, or it's the Smartmatic and Dominions of the world, because they bought into this fake lie. And so there's a whole challenge to the underlying business model. That's that existential threat that you talked about. And then the money. I mean, as much money as Fox has or had, any company, even after it burns through all of its insurance, if it's hit with billions of dollars of settlements, and they got to settle this case. If they thought it was bad to go in front of Judge Eric Davis in the court across the street, which is the Superior Court of Delaware, where they lost horribly, got in terms of decision-making by him, and had to settle the case for $787 million with Dominion. Wait till they see Judge Laster, Chancellor Laster. I've been in front of him. I've had him, including some of the same law firms that are vying to be the plaintiff's counsel, reject a settlement that we proposed as the company that I worked for, along with these. It was the only time we were ever in harmony together. I was standing shoulder to shoulder with the plaintiff's lawyer saying, Judge, this is the proposed settlement of the case. And he said, no, I don't like that one. Go back to the drawing board, come up with more money. I think the lawyers are getting too much. I think the company's not paying enough. And then, that's Travis Laster. He has always been a wild card. One of the reasons that companies like to be in Delaware, because some people might be thinking around the globe, why do we keep talking about Delaware? It's because Delaware law is so well established, and the courts are so well set up, and the judges, to handle business disputes, that companies incorporate there in order to get the benefit of Delaware law. But of the chancellors on the Delaware Chancery Court, Travis Laster is the wild card, and he's the one, if you're in the position of the Murdoch family, you did not want to see pulled and assigned to this case, and he's assigned to all of the cases involving Fox. You and I will report on what happens on the 23rd when the plaintiff's class gets, when the plaintiff's lawyers get picked. They have to settle this case. They're going to. It's going to come out of the insurance money and the pockets of Rupert and Lachlan and all the other little Murdochs, as well as people like Paul Ryan, who used to be the Speaker of the House, who spends time being on boards. He's named as a defendant as well in one of these cases.
Big news there. And look, you have to remember, Fox was built over generations. And the plan to build Fox comes from a memorandum sent by Roger Ailes back in 1970. Okay. And it was developed, this plan, to have a Republican propaganda network. That was like the title of the memo. It was in the 70s. I'm not sure if it was in 1970 itself. But it was building a right-wing media echo chamber was basically the title of this. And Roger Ailes developed it, eventually with Rupert Murdoch. And they were able to generationally build this machine that has caused a great deal of harm to our democracy. So as I think of the state of the union of our pro-democracy network here at MeidasTouch, it's strong, with shows like LegalAF, the MeidasTouch podcast, and with all of our hosts and contributors here, who I'm so proud to share with you each and every day. But we have to remember that it's both a short-term objectives need to be achieved, but also generational objectives need to be achieved. And that's how I view the growth of this network. I think of what can I do every day to make sure we give you the best content here, and working with the best in the business, whether it's Michael Popok, Karen Friedman-Diflo, or my brothers or all the others on a day-to-day basis. That's great. But behind the scenes, Popok, myself, and our great team of contributors are also thinking ahead 2 years, 5 years, 10 years, 15 years, and longer to build something foundationally where you can have a force for truth, a force of facts, a force of evidence, a force for compassion. And that's why I so appreciate everybody in this audience to have a movement built on intelligence, compassion, and being unapologetically pro-democracy. So thank you all. We don't have outside investors here at the MeidasTouch Network. So if you want to help build this network, we try to do it in fun and interesting ways. You can already see the fruits of that at work with the launch of MeidasTouch.com, our great editorial team there, led by our editor-in-chief, Ron Filipkowski, but with a whole host of great writers and editors that are putting forward content every day. That's thanks to your helping us grow this network. So if you want to help grow this network more, join us at patreon.com/MeidasTouch, patreon.com/MeidasTouch, MeidasTouch, and become a member there. Separately, you could become a member of the YouTube channel by clicking that little $sign. You could gift memberships to people as well. The YouTube membership and the Patreon memberships are different. On the Patreon, we will be doing a live Zoom, me and the brothers, next week. And we have all of the details that's listed there. So it would be fun to meet you as well and to say what's up to you. We also have Michael Popok, Karen Friedman-Diflo's origin stories. Their biographies are posted. They're a video biography origin story on patreon.com/MeidasTouch. So check that out. Also go to store.MeidasTouch.com for the best pro-democracy gear and LegalAF gear. Of course, it's 100% union made, 100% made in the US. I love that LegalAF gear designed by Karen Friedman-Diflo and Michael Popok, store.MeidasTouch.com. Thank you all for watching this week's episode. episode of Legal AF. We will see you next time. Shout out to the Meidas Mighty.